Hello everyone, welcome to week 14 of business law. This week we're going to take a little journey through the world of employment law. What we're going to cover this week is looking at the legal issues surrounding employment, and there's quite a few of them actually. And this is a very practical section of material if you ever plan on owning or running a business, because usually that involves hiring, promoting, firing employees and those sorts of things. And that's the kind of issues that we'll be looking at primarily through this material. Hiring employees is fraught with potential legal pitfalls, and we'll look at that more toward the end of this material, but there's certainly a lot of things that you want to keep in mind that common sense might tell you is fine to talk about during a job interview, for instance, but under the law you should probably avoid certain subjects, and so we'll take a brief look at that. So the first thing we're going to do is look at the nature of the employer-employee relationship, and also look at some legal protections that employees have thanks to statutes that have been passed over the years. Then we're going to look at laws designed to ensure that everyone has a fair shot at landing a job and doesn't experience prohibited types of discrimination. The default rule is that employers can hire and fire employees as they see fit, and that's normally the case unless there's one of these exceptions that comes in that we'll look at a little bit later, but that's the general rule. However, there are statutes that have been passed that limit the employer's freedom in order to protect the employees from sorts of discrimination and things that we think are unfair and ought to be illegal. When we're looking at types of employees, there are basically two types: the kind that have an employment contract and those that don't. The vast majority of employees in the United States do not have an employment contract, and so they are what we call employees at will. Usually, in fact, the only employees that have a contract per se are those who are in top management positions or those who have some kind of special skills or training or something like that. For example, a doctor who goes to work for a certain hospital might be under contract with that hospital. So they'll negotiate a salary and benefits and both sign a contract. The doctor agrees to work for the hospital for a certain length of time for a certain amount of money. Also, a classic example is teachers who have contracts with a particular school district. And so the contract will help the school district ensure it has a teacher for a particular classroom for a year, and the teacher will have some kind of guarantee of having that job for a year unless they violate the contract or something like that. And so if you have that special skill, training, certification, whatever, you may end up getting a contract and working under contract. But again, that's pretty much the exception. An employee who is under contract has certain rights that are spelled out in that contract. Commonly, the contract will go ahead and say when and why the employee might be fired. It will define what a fireable offense actually is, so you will know going forward, what you can't do if you want to keep working there. If the employer fires the employee in violation of the contract, the employee can sue for breach of contract. What actually usually happens is, let's say that our hospital hired the doctor to work for them for a year, and after 6 months they realize they really dislike that doctor for some reason. He hasn't done anything to violate his terms of the contract, but he has no bedside manner, or he's just a jerk, or isn't doing a good job or something, but not enough to actually breach the contract. They just don't like him. They can tell him to get lost, but they have to keep paying him for not working. Or he can turn around and sue them for breach of contract. So they can tell him to stay home, but they have to keep paying him. And so that's how it works when you're under contract. And you do have some protections there, and if one of the parties violates the contract, the other one can sue for breach. And likewise, if the employee quits before the end of the contract term, the employer could sue the employee for breach of contract. But theoretically, it doesn't always happen, but they could, because there is a contract there. So employees under contract are fairly well protected, and they have a certain amount of job security, at least for the term of that contract. As we said, though, the vast majority of employees do not have an employment contract, and they are called at-will employees. And they're called at will because the employer can fire them at will whenever the employer feels like it. And also, the employee can quit for any reason at any time. If you want a good reference, you're supposed to give 2 weeks notice, but you don't have to. You can just walk out the door and keep walking. And so either party can terminate the employment relationship anytime they want. And so it just keeps going at the will of both parties. And so we call it at-will employment. For example, let's say that Ned hires Sally to be a secretary in his real estate office. Sally is an at-will employee. She does not have a contract. Sally likes to wear clothes that are red. While Sally is dressed very professionally and is the best secretary he has ever had, Ned hates the color red. Ned fires Sally. Is that okay? Well, yeah, it is, because she was an at-will employee. And since she was an at-will employee, Ned has every right to fire her. Even though his reason was completely stupid, it doesn't matter. He has that right. In fact, he could fire her for no reason at all. For example, let's change the facts a little. Let's say that Ned hires Sally to be a secretary, but 3 weeks later, Ned's friend Steve asks him to give Steve's daughter a job. Ned tells Sally, "You're doing a great job, but you're fired." Ned then replaces Sally with Steve's daughter. Is there anything that Sally can do about that? And the answer is no. Ned is perfectly within his rights to fire Sally. She's an at-will employee. She's not under contract. He can do this for no reason at all. Sally did nothing wrong, but it doesn't matter. This relationship can be ended by either party at any time for any or no reason whatsoever. At this point, you may be feeling sorry for Sally, or perhaps yourself if you realize that you're an employee at will. But remember that at-will employment is a two-way street. For example, let's say that Judy is hired to be a receptionist at a law firm. It is the best job she's ever had with great salary and benefits. However, Judy begins studying Buddhism and decides to go to Nepal and find herself. One day, she abruptly tells her boss, "I quit," and goes home. So, in that situation, Judy can expect a poor reference from her employer after quitting abruptly for no reason. But she had every right to do so because her employment was at will. She was not bound by a contract, so either she or her employer could terminate the employment relationship at any time for any reason or no reason at all, because she is an employee at will. So if you work at a job as an at-will employee, you may be feeling a little insecure right now. Looking at this situation, you could be fired for any reason at all. And to be honest with you, I'll give you some Dave Ramsey advice. If you don't know who he is, Google him sometime. He has some pretty interesting things to say once in a while. But if you work as an at-will employee, your only real job security is your ability to land another job. And people like to think that, I'll put in my 30 years and get my gold watch and retire. And if I do a good job, they'll keep me and I'll get promoted. And maybe it used to be that way. I don't know. In our parents' or grandparents' generation. But anymore, times change, layoffs happen, companies get restructured. So you'll need to look for your security as your employability. How likely am I to be able to get a replacement job if something bad goes wrong with this one? If you keep your focus on that, maybe that will help you sleep at night a little bit better. I don't know. So I'll just throw in that practical advice for free for you. Well, your employer can fire you because it's trying to save money. It's getting rid of your department. You're doing a bad job just because it feels like it. Again, really any reason. But the flip side of that is your employer knows that its employees can walk off the job for any reason or no reason, leaving it high and dry. So this really is a two-way street. You feel insecure because they may get rid of you for any time, any reason, basically. But your employer is suffering too because they know that their employees can walk off the job for any reason, just not show up for work or whatever, and it'll leave it in a real pickle. So if it helps you any, if you're feeling a little insecure about at-will employment, think how frustrated employers get when they have a high rate of employee turnover. If you've ever been in the position of having to hire employees, especially for low-level jobs, that can be pretty frustrating, having to hire again and again and trying to fill those positions. Well, in America, we have a pretty fluid labor market, which means that people start jobs and leave jobs, and companies hire and fire and whatever a lot. And really, that's not a bad thing, because what we lack in security, we make up for with freedom. Isn't it nice to know if you end up in a bad job that you hate, you can leave that job whenever you want and you won't get sued? There's nothing legally that's keeping you in that position. And as an employer, isn't it nice to know that you can get rid of lazy, unproductive employees without having to go to court or fill out lots of government forms? You have the power to let people go if you need to, which is unpleasant, but sometimes needs to be done. So for both sides, there's some insecurity, but there's also a huge amount of freedom. So there are good things and bad things, just like anything else. But overall, the system seems to be working fairly well. I will take a moment to point out that not every country follows this model. And a good example of that is our friends over in France, who are a little bit more socialist than we are on the whole. And they have regulated their labor market quite a bit. There's all kinds of government involvement in the hiring and firing of employees. Before an employer can fire a bad employee, the employer must carefully document what the employee is doing wrong and fill out lots of forms. They have to cover their rear end before they are going to fire someone. Even if they're obviously a bad employee, they need to be really careful, because if they do a bad job, the fired employee can go to the government and get the company in trouble. And so they have to follow particular procedures, document everything, and fill out lots of paperwork. If the government doesn't agree that the fired employee was doing something wrong, the employer can get into trouble with the government. So we don't want that, obviously. And even if the employer wants to lay off employees due to economic conditions, we've had a bad couple of quarters, we're hemorrhaging money, we have to trim the workforce. Well, the employer first has to file paperwork and let the government examine its books. And only if the company can prove that it is in some kind of desperate financial situation will the government allow it to go forward with a layoff. And so again, we have the government being involved every step of the way here, trying to protect employees, but getting itself involved in the running of your business in the process. Well, while this system was intended to give employees additional job security, it has had some nasty side effects that were probably not intended. Since it's so difficult for companies to fire a bad employee, they are extremely reluctant to hire new ones, because when you hire a new person, that is taking a risk, because you don't know how that person's going to turn out. So if you're going to hire a new employee, especially one that doesn't have a long track record of success, you're letting yourself in for real trouble if that turns out that they're bad, because you might have to go get government approval to get rid of them. It could be that whatever they're doing that's annoying you isn't enough, to meet the government standards, and so you're stuck with them. And so they're taking a real risk when they take on new employees, and so that makes them really hesitant to hire new people. And so it's really hard to get a job because you really have to convince your potential employer that you're a real star and a winner, and they're not going to want to have to go through all this paperwork to get rid of you if that turns out not to be the case. And so the unemployment rate among recent college graduates is extraordinarily high because they have no track record. We can look at their grades in school, but we have no idea if they're going to do a good job or not. And so if there's someone out there that has any kind of experience at all, the employers are probably going to lean that direction rather than hire someone who's new and unproven. And so if we do get more involved and try to give employees more job security this way, there are side effects to it. And so our system may not be perfect, certainly, but do understand if we try to change it, that may not be perfect either. So different ways to go about it. But our American system has good things and bad things about it, but it tends to work most of the time, even if it does make us feel a little unsecure, knowing that we can get canned for any or no reason. Well, our system is still based in the present day on the idea of at-will employment. However, we now have additional protections for employees. We'll talk more about this later, but it's a violation of federal law not to hire someone because of their race or gender, for example. That type of discrimination has been outlawed by Title VII. We'll look at here a few slides down the road. But at-will isn't, complete freedom in our system. We do have some basic protections. Also, an employer cannot fire an employee if doing so would be a violation of public policy. And let's take an example of this. I think that would probably make it more clear than any explanation I can give. It says, say for instance, that an employer orders an employee to do something illegal, like destroy documents that show that a product being sold to the public is dangerous. Then the employee refuses to break the law and is fired. We want employees to do the right thing, so courts would allow that employee to sue his former employer for wrongful discharge. And so here, the company is trying to do something shady, and we have a stand-up employee who's a whistleblower and, a goody two-shoes and says, no, you can't do that. That's illegal, and so gets canned. Well, they can go back and sue their employer and say, no, I shouldn't have been fired. I was trying to uphold the law while you were trying to break it. Well, we certainly don't want to encourage employers to fire employees who are trying to obey the law. That would be bad public policy. We don't want to encourage that kind of behavior. And so there can be situations where we will really put restrictions on the at-will concept of firing somebody for any reason if they're violating public policy here. Sometimes we may have a situation where it appears we have an employee at will, but the employer has done something, perhaps by accident even, that will turn that employee into being a contract employee. For example, say that an employee is hired on an at-will basis, but then the employer is going above and beyond here. They get put together this beautiful employee handbook that carefully sets out all kinds of company policies. It also says that no employee will be fired unless his performance falls below a certain standard, sets all of this stuff out in excruciating detail. Well, that handbook may create an implied in fact contract with the employee. So if the employer tries to fire the employee in a way that violates the policy in its own handbook, then a court may allow the employee to sue for breach of contract. And that's happened in some cases in the past where a company would fire an employee in violation of its own policies. And the employee would show up in court, waving the employee handbook and say, look here, on page 52, paragraph 3, subparagraph E, it said that you couldn't fire me because of this, but you did. And so if the employee can convince the court that this handbook became, in fact, a contract, that they continue their employment based upon this handbook, and that, they can maybe show breach of contract there, even though the employer never really intended to hire them on a contract basis. The employer can kind of create a contract somewhat by accident in situations like that. So there are some interesting cases out there where we can turn an at-will employee into a contract employee in a situation like this. Let's talk now about some employee protection that statutes have provided, and one of those is the workers' compensation system. Up until about 100 years ago, the legal system was very unfriendly to injured employees if you were injured on the job. So if you were, working in the coal mine or something and got hurt and wanted to be compensated for your injuries, as a worker, you would be forced to try to sue your employer for negligence. And that was really your only recourse. Unfortunately, the law was very employer-friendly, and this almost never worked. Even if the employee had the money and resources to pursue litigation, which was usually not the case, they were usually, working paycheck to paycheck, and they had missed a few because they were hurt. So they normally couldn't go hire a lawyer anyway. But if they could, the law was very employer-friendly. These suits usually didn't get very far. So we would have sad situations where we'd have a faithful employee who would get hurt doing the company's work and then not be able to continue working, so they would get fired because they couldn't do the job anymore, and then they would sit at home disabled and unable to get another job because they got hurt doing their first job. And so that's just sad and unfair, and we don't like that. And so statutes were passed to fix it back in the progressive era, early 1900s. A new scheme was kind of set up to protect employees who were injured on the job. So now every state has what we call a Workers' Compensation Act. So if a worker is hurt on the job, he will file a claim with a state agency that administers the workers' compensation system. The agency will then look at that and decide whether to accept or deny the claim. And so they will look and see, well, was the employee actually hurt? And if so, was he hurt doing his job? And is that why he is disabled? And if he's disabled, how much? And so on. So the agency will take a look at this claim, figure out what to do with it. If they end up denying the claim, the worker can appeal the decision several times, usually ending up in a regular state court system after a couple of steps. So they will start working with this agency and then actually end up in a regular courtroom at some point if the appeals continue. And the Workers' Compensation Acts require that every employer provide workers' compensation insurance coverage, and that's what's being administered here by the state agency, is that there is insurance for getting hurt at work, basically. And the state agency decides, looks at the different claims and decides which ones to pay and which ones not to. But everyone has insurance. So theoretically, at least, if you're hurt on the job, you can file a workers' compensation claim. The state agency will accept that claim and then pay you money because you were hurt and take care of your medical care and that sort of thing. So if the employee is hurt while on the job, this insurance is there to provide the employee with medical treatment. They will make sure that you get, the the doctoring that you need. They will also compensate the employee if he is partially or completely disabled and can't continue to work. So they will give you disability payments. So injured employees do not have to sue the employer anymore, and the worker doesn't have to prove that his employer was at fault. And that was where employees got tripped up in the past sometimes. Maybe the employer actually did nothing wrong, and here they are suing them for negligence. Well, they weren't actually negligent, just sometimes accidents happen. Sometimes you're working in the coal mine and a rock falls on you, and it's not the employer's fault. It just happens. And so in this system, it's really not based upon fault. It's just, were you hurt working on the job? And if you were, then we will give you some money to take care of that. So if the employee was hurt and the injury was employment related, then the workers' compensation insurance will pay. So only if an employee is doing something outside of the scope of employment is he not going to be covered. And so normally if he's on the clock working for the company, we're not going to have a problem with that. But an example where we might would be, let's say the employee took the company vehicle out to a bar during work hours, got hurt in a bar fight. Well, obviously that's outside the scope of employment. So those kinds of situations don't happen all that often, but sometimes there might be an argument about course and scope of employment, just like we'd have with respondeat superior, kind of the same sort of idea, but usually that's not too big of an issue. So any normal on-the-job injury will ordinarily be covered, and it doesn't have to relate to what the employee was hired to do even. For example, let's say the employee was hired to be an accountant. While he's walking to the conference room one morning, he slips on a wet spot on the floor and breaks his ankle. Well, since he was at work and the injury was employment related, workers' compensation would cover that injury. They weren't hiring him to do any kind of physical labor or anything. This broken ankle had nothing to do with him working on spreadsheets, being an accountant. But because he was at work, he was doing what he was supposed to do, that would still be covered under workers' compensation. If workers' compensation does cover an injury, then the employee cannot sue your employer even if you want to. Workers' compensation is said to be the worker's exclusive remedy. And so that was kind of the carrot that helped employers kind of swallow this system a little bit, because it's providing all kinds of protection to the employees, but it also provides some protection to the employer as well, because that protects them from getting sued by their employees. So even if the employer is negligent, they messed up somehow and that caused an employee's injury, ordinarily they can't be sued for a tort in the regular court system because the workers' compensation is the employee's exclusive remedy. Sometimes, though, we will have a situation where an injured employee would like to sue their employer if they could, usually because the workers' compensation benefits, frankly, aren't always that great. You're not going to get rich on workers' comp benefits. So sometimes if the employer really did screw up, and then the employee would rather go ahead and sue the employer because they could actually get more damages from a lawsuit than they could from doing a workers' compensation claim. So if they could sue the employer, it would actually be a benefit. So sometimes they want to get around this provision. However, if the Workers' Compensation Act applies, the worker can almost never go ahead and sue his employer for his injury. The only exception to that is if the employer either intentionally injures the employee, does something really nasty, or acts so recklessly that the law allows an exception. And like, for instance, the law in Missouri says if there's something extra that's going into it, that's not mere negligence, but there's something extra that's really egregious, we will sometimes let the employee sue the employer. When I was in practice, I remember a case where I think it was some company vice president or something that wore a suit and tie every day and didn't have any idea what he was doing, showed up at a construction site, because this was a company that did kind of construction sorts of things, and decided it would be really fun to run a crane. And he had no idea how to run a crane, but he jumped up there in the cab and started pulling levers and ended up hurting one of his employees. And so in that situation, the court said, well, that's so stupid and reckless and egregious that we will let the employee sue the employer in that situation. And so there has to be something really majorly going on here that the employer is doing that's just really stupid for this to happen. But usually if workers' compensation applies, the worker is stuck with that. But at least now we have a system to where workers' injuries will be covered. If they get disabled on the job, there'll be benefits for that, and they'll get the medical care that they need. And they don't have to go sue their employer. So the workers' compensation was a huge improvement over the old system that we used to have long ago. Besides the Workers' Compensation Acts, we also have other statutory protections for employees, and that includes the Occupational Health and Safety Act, otherwise known as OSHA. And while workers' comp pays injured employees for their injuries, OSHA is designed to prevent the injuries from happening in the first place. And this is a federal law that creates safety standards that companies must follow throughout the United States. And along with setting some standards for safety, it also created a federal agency, the Occupational Safety and Health Administration, which it says commonly called OSHA, with the power to make workplace safety regulations. And they also have agents that they will send out to look over workplaces, see if anything's being violated. And if there are rule violations, they have the power to issue fines and that sort of thing until the workplace is back in compliance. For examples of what OSHA might be interested in, if we have workers that are working in a noisy environment, maybe it's some kind of factory environment where the noise level is above a certain decibel level, where it might impact their hearing, OSHA will require that those workers have to have proper hearing protection. And there are scientific standards set up that will tell you exactly what kind of protection you need and how loud the sounds have to be before you need it and all that kind of stuff. There are regulations about that kind of thing that OSHA will define and then enforce. Or another example, if you have your employees, working around some kind of dangerous chemicals, OSHA will set standards on what kind of protective gear they have, their goggles, the suits that they wear, and all that kind of stuff. And so, it doesn't just deal with ultra hazardous stuff, though. There's all kinds of rules that businesses have to follow to make sure that their employees are protected. And if a business isn't in compliance with the regulations, OSHA can cite the company for a violation. They will have to both correct the problem and then may also have to pay kind of a nasty fine. And so if you're involved in some kind of industry, you have to know what OSHA requires and toe the line on that, or you will end up in trouble with the federal government. Another statute we have is called the Fair Labor Standards Act. And that's another federal statute designed to protect workers. It does several different things. For one thing, it prohibits child labor. And that was a problem a long time ago, not so much anymore because it's been outlawed, but 100 years and more ago, kids were put to work in all kinds of places, like even coal mines and things. And the thinking on that was, we put them in hazardous jobs, and it's really sad if a child gets killed doing one of these hazardous jobs, but if the dad gets killed, the whole family's going to starve. And so people had lots of kids, and they would put their kids to work, in dangerous places sometimes. And if you lost a kid, it was really sad, but you could have more kids, but you couldn't replace dad. And so that was, not really seen as economically impactful to the family in some ways, which, is kind of abhorrent to our modern sensibilities. But historically, that's the way it worked. Kids were put into all kinds of dangerous jobs and met horrible kinds of ends, sometimes working in coal mines and factories and all kinds of places like that. Well, the FLSA prohibits child labor in hazardous jobs, period. Prohibits nearly all employment for kids under the age of 14, and has other restrictions on kids who are 14 or 15. Sometimes they can work a certain number of hours in non-hazardous jobs. Those who are 16 years old and above can work in non-hazardous jobs as much as they want. There's still some restrictions, I think, on that. But anyway, it does deal with child labor quite a bit. And there are exemptions, though, most importantly for working on a family farm. If you ever grew up on a farm or was around that, usually the kids are pitching in and trying to help on that stuff, too. And so the law is written to where, it doesn't impact that usually, but if you're going to go get your kid working hourly, working in the coal mine or something, you better get a different idea because that has been outlawed now. So there are restrictions on that. The FLSA also does some other things too, including setting the federal minimum wage. As you probably know, businesses have to pay above a certain number of dollars per hour to their workers, and that floor is set by the FLSA. It also says that some employees who work more than 40 hours have to get paid extra for overtime. Not all employees get overtime, but some do. And if they meet these qualifications, you have to pay them time and a half or sometimes more for overtime. Some employees, and typically those with lots of kind of special training, special skills, can be paid a set salary, and they are not paid by the hour. And since they're not getting paid by the hour, they don't get overtime, because overtime would be working more than 40 hours a week when you're an hourly employee. We say that those employees are exempt from the overtime rule. So if you ever hear about an exempt employee, that just means that they are not hourly. They get paid a salary. And so, for instance, my day job is working for Missouri State University. I am salaried, and so if I have to work 20 hours a week or 80 hours a week, my paycheck is exactly the same. Because I guess I have enough special skills and training that I'm an exempt employee. They don't have to pay me by the hour. But, in the past, I've had hourly jobs too. And so if I worked more than 40 hours a week, if I had to clock in and clock out, but if I was there for more than 40 hours, they had to pay me time and a half. And so it depends on the type of job that you're doing. Some employees are exempt and some are not. Usually, it's the people who are in the management positions who have, highly skilled backgrounds, think like lawyers, nurses, engineers, somebody with a lot of school, and is putting those skills to use for their employer. Those are the kind of people who are exempt, and we can, pay them a salary. When I was a practicing attorney, my goodness, sometimes we were, I actually literally had all-nighters, where I was there all the time. Well, they weren't paying me by the hour. I just got a salary per year, get a check every month for the same amount, no matter how hard I was working. And so that's what these exempt employees deal with, which is actually, not a good thing if you like to get paid a lot of money, because hopefully their salary is high enough it'll compensate for that. But you can be putting in 80 hours a week and your check doesn't get any bigger, and sometimes that's a little bit discouraging. But non-exempt employees are the ones that these overtime rules actually do apply to. And so if you're non-exempt, you're paid hourly. So you clock in and you clock out, and you get paid for your time, how much per hour. That's how you get compensated. And so if you work more than 40 hours in the week, then you must get paid overtime, which again is usually time and a half. So 150% of your normal hourly rate. That's what you would be entitled to. So again, it depends on how you're classified. Sometimes businesses will get in trouble with this because they will try to classify employees who ought to be non-exempt as exempt employees because they don't want to pay overtime. And sometimes that'll kind of puff up their employees a little bit. Oh, look at me. I'm like the boss. I'm important and I must have lots of skills and abilities. And, that may be fine, but once in a while the government will investigate these kinds of situations and say, you're wanting to pay your secretary a salary and call her an executive assistant or something, but really she's answering the phone and typing things for you, and you need to be paying her hourly and be paying her overtime. So sometimes businesses will get kind of caught up in this, and the government will come poking around, and they'll get in trouble if they're misclassifying employees. So something to be aware of there. Another statute that we have at the federal level is the Family and Medical Leave Act, or FMLA, which allows employees to get unpaid time off from work to deal with certain medical situations that they or their family is dealing with. And again, this is unpaid leave, so that's important to recognize. But the situation that would qualify for this might be some kind of serious health issue or even the birth of a child. You could get time off for that. If you have a qualifying event, something that triggers the statute here, the employee can get up to 12 weeks off of work. And that's unpaid leave. You don't get paid for that time. How it helps you, though, is that your job will still be there when you come back to work. And so they can't replace you during this time. They have to let you have that time off and then let you come back to your job after those 12 weeks are over. Usually what happens in real life when this occurs, an employee who has one of these situations come up will use up all their vacation and sick time that they have so that they will still get a paycheck for as long as possible. Then they will use that unpaid FMLA leave for the rest of the time they have to be off work. And so they'll be gone on FMLA as little as possible because, again, it's unpaid leave. So they'll use up all their vacation and sick time first. Only larger employers with 50 or more employees are subject to the FMLA, but for these larger employers, they have to let employees have that time off to deal with these situations and let them come back to work when it's over in accordance with the law. So they have to be careful of that. I'm going to talk about some other government programs now that affect employer-employee relations. One of those is the Federal Unemployment Tax Act. And that requires that every state set up some kind of unemployment compensation system. And so this is part of what we sometimes call the social safety net. Sometimes people are out of work, and we really don't want them living on the street and starving and their kids starving and all that if we can help it. And so this is set up to help folks who are thrown out of work for a period of time before they get back on their feet. This is just designed to help them make sure they can, pay at least most of their bills and provide for their families, at least partially, while they're dealing with hard times. Each state can design its own system under the Act within limits. It gives the federal law gives some guidelines, but each state can kind of design its own system as long as it colors between the lines there with what the federal government has set up. The way this works, employers are required to pay money into the state for every employee that they have on the payroll. So this is a tax on employers. This money that is collected is then placed into a fund for people who lose their jobs. Then, if an employee is laid off or fired and weren't guilty of illegal activity or some kind of serious misconduct, then they can file a claim with the state for unemployment compensation. And when they file that claim, when it's approved, the fund will then pay them money for a certain amount of time, so long as they are looking for work. So as long as they are out actually actively trying to find a new job, this insurance system basically will pay them some money, probably not as much as they were making, but they'll still have some income while they're out there looking for a job. And the state agency will keep tabs on that. You have to report to them who you filed applications with and how many job interviews you had that week and that sort of thing. So you have to be actively trying to land a job, and it doesn't last forever either. There's always a limit on how long you can be on the unemployment system, and it'll run out eventually if you don't find a new job, but it does give you kind of a little bit of a safety net there. It gives you a certain amount of time to find a new job, and you'll get some income from this system while you're out looking. Important to note, if you decide to quit your job, you aren't eligible. It has to be not your choice to leave, either that you were laid off because of the company's fallen on hard times or you were canned. But if you just decide, I quit, then that's not going to work for you. The system is entirely funded by the tax on employers, and employees pay nothing into the system. So kind of a good deal for the employees. But the employers have to be contributing money to the system for every employee that they have on their payroll. We also have the Social Security system, which pays money to employees who retire after a certain age, and that's usually why we know about it. It also does some other things too, including paying money to workers who are totally disabled. And there is a program to give death benefits to the families of employees who die. It's usually not a huge amount of money, but if your spouse passes away and has been working and built up enough credits and stuff, they can get a check from the Social Security Administration to help them out. Totally disabled means you can't get any kind of a job, basically. Not just the kind of job you had before, but any kind of gainful employment. It's pretty strict on that. So, kind of hard to qualify for that, but there are folks who are just completely, totally disabled who can't, hold down any kind of job, and they can apply if they've had enough work credits built up, they can get Social Security disability. And then, of course, if you make it to age 65 or whatever and meet all the requirements, then you can retire and get a check from Uncle Sam every month. This is actually funded by a tax on both employers and employees. And if you look at your paycheck, you may see something called FICA, which has a minus sign in front of it because they're taking money out of your check. And this is called the Federal Insurance Contributions Act, and this is just the system they have for taking a chunk out of your check every pay period to put it into the Social Security system. So you will be funding somebody's retirement benefits probably, and then the idea is when you're old enough to be taking out of the system, some young workers and getting their paycheck attacked so that they can pay for your benefits. So that's how that is set up. Employees pay half of the tax through the FICA contribution, and the employer pays the other half. And so both the employer and the employee are helping fund this system. If you are self-employed, like if you're, have your own business, then you have to pay both halves of the tax yourself, and that's what is referred to as a self-employment tax. So if you're, working for somebody else, you're only paying half of it. If you're working for yourself, you're the employer and the employee, so you're paying both halves of it. And so the self-employment tax is kind of a nasty little surprise sometimes when people who own their own business or work for themselves end up doing their taxes. Social Security is a retirement fund and disability insurance policy, and you're contributing to it whether you like it or not. So the government has set that up for you, again, part of that social safety net to make sure that old people don't starve once they've retired, and also to make sure that disabled people have some sort of income if they're totally disabled and can't provide for themselves. We're going to shift gears now and talk about equal opportunity unemployment. And this is the area of employment law that can get employers in a lot of trouble sometimes if they don't do a good job of managing things. So some fairly practical information if you're involved in any kind of business that hires employees, basically. We already talked about this a little bit, but the at-will employment philosophy originally meant that you could hire or fire whoever you wanted, whenever you wanted to, for any reason or no reason at all. And historically, it was pretty unlimited. It didn't matter what your reasoning was. If you wanted to can somebody or you wanted to hire or not hire somebody, we didn't, care about what was going on between your ears in that decision-making process. But that has changed. But historically, if you didn't like the person because she was black, you could not hire her for that reason. If you wanted to hire only men and not hire women, that was okay. And the government didn't get involved in that. But beginning in the 1960s, the federal government stepped in to prohibit certain types of discrimination. Back when we had the civil rights movement going on, and African Americans were, fighting discrimination and segregation and those sorts of things, and the women's rights movement started gaining force, and feminism and that sort of thing. So there was really a groundswell of support for trying to outlaw this sort of discriminatory practices, that you shouldn't be hiring and firing people based upon who they were, and rather than the job that they were doing. And so there were certain types of discrimination that we were decided to outlaw. If you're ever in a position to hire employees, these laws are something you should familiarize yourself with. And I'm going to give you the broad outlines of this, but hopefully if you end up in HR, you will know this stuff forwards and backwards and pay attention to any changes that come down the line, because you can get in big trouble if you don't know what you're doing. Well, we're going to talk about first the EEOC and Title VII. There are several different federal laws that have been passed to prohibit certain types of discrimination. One of the most important was the Civil Rights Act of 1964. And one section of that act, called Title VII, deals with discrimination in employment. Just like any big statute, it was split up into parts or titles, and Title VII is the one that we're going to be paying attention to here. In 1972, the Equal Employment Opportunity Act was passed and provided additional protections. And so that created the Equal Opportunity Employment Commission, or EEOC, whose job it was to enforce those laws. And so these two statutes and their attendant regulations and this agency are charged with prohibiting discrimination in employment. So what Title VII does is prohibits the basing of some kind of employment decision, hiring or firing or promotion for that matter, on the classification of an employee as a member of one of 5 protected classes. And these are, it's not just any discrimination, it has to be involving these 5 protected classes, or Title VII doesn't care about it. And those protected classifications are race, however you identify yourself racially, color, meaning the color of your skin, national origin, meaning what country you are from, whether you were born in the United States or somewhere else, or that kind of thing. Your gender, your sex, whether you're male or female, and your religion. So those are our 5 protected classes, and we do not allow employers to discriminate on those bases. If you're trying to hire or fire someone based upon one of these things, you are violating Title VII federal law. You'll be in big trouble. And so these are the big 5 classification protected classes under Title VII. And so, despite the employment at will doctrine, which is still the general rule, it is illegal to hire or not hire someone based upon one of these 5 classifications. So this is a big exception to employment at will, which is the general rule. So you cannot base an employment decision on one of these 5 protected classes, whether your candidate, belongs to one of these or doesn't belong to one of these groups and one of these classifications. You can't do that. It's also illegal to base decisions regarding promotions, rates of pay, raises, the amount of benefits on any of these classifications. So it's not just the hiring or firing decision, but also all these other kinds of things that come with the territory of employing somebody. Remember, you can still fire someone for almost any reason. Whether you don't like, if they, that secretary we saw that wore red and we didn't like that, it can be stupid, can be no reason. But if you choose to fire someone because they're a member of one of these classes, then that is no. You can't do that. So we leave employment at will largely intact, but we do have this big exception for these 5 groups. You may notice that sexual orientation is not a protected class under federal law. Now, the reason for that, probably if we were writing Title VII today, they'd probably throw that in there, but it was written back in the 60s and 70s, is when we developed a lot of these laws. And so back in those days, the American Psychological Association still thought homosexuality was a mental disorder. So the world has changed a whole lot in living memory on that issue. So sexual orientation is not a protected class under Title VII. Having said that, some states have prohibited discrimination on this basis. So it depends on what state you're in. Like Colorado comes to mind that has actually prohibited sexual discrimination on sexual orientation. Federal law has not. And so there's no federal case for it, but there may be a state case. And so as an employer, you need to know what your state is doing on this sort of issue, because states are free to go further than the federal government in trying to prohibit discrimination, and many have done so. So as an employer, you need to be aware not only of federal law, but also the laws of your particular state so you don't run afoul of one of these rules. If you're an employee who believes you've suffered prohibited discrimination, the first thing that you have to do is to file a complaint with the EEOC, the Equal Employment Opportunity Commission. That agency then has a certain amount of time to decide whether it wants to investigate the claim, and they may. They may decide that they want to come check things out, and if they find something has gone wrong, they'll try to make it right. They may fine your employer, whatever that they want to do in enforcing the law here. And so before anything else happens, you have to give the agency a chance to make it right. Normally, though, most cases, what happens is the EEOC doesn't have an unlimited amount of resources to investigate these kinds of claims. And so unless it's really, truly egregious and really piques their interest in some big way, what they'll do is they will send a letter to the person who made the complaint saying that the agency has chosen not to investigate the claim. And so that's kind of bad news in a way. The EEOC doesn't have time for your claim, but it's also good news in a way, because this letter also gives the person the right to sue the employer for violating the statute. Now, you can't sue the employer for violating the statute unless you've gone through the EEOC system first. But if they choose not to do anything, then you can just go to court and sue your employer, or former employer probably, or maybe the person you thought should have hired you and didn't, whatever the case may be. So courts will not allow someone to sue under Title VII unless the EEOC declines to intervene and sends what is called the right to sue letter. And so they will just say, thank you for making your complaint. We're really sorry. We don't have time to check it out. But, if you think your rights have been violated, you may go to court and sue your employer. And so they will give you that right to sue letter. And that is your ticket to get into federal court to sue this employer for whatever they were doing wrong. There are 2 types of claims that can be brought under Title VII. The first one is what we call a disparate treatment claim. And this just means that the employer treated me different because I'm part of a protected class. And so the disparate just means different, and treatment, is how they're treating you. So because you're black, because you're a Jew, because you're a Christian, because you're originally from Paraguay, whatever it is, if you're saying that this employer was mean to me because of my membership in one of these groups within one of these 5 protected classes. And so that's, focuses solely on, how they're treating this individual, and that's a disparate treatment claim. So, such a claim might be brought if a person was not hired because of their race, was not promoted because of their gender, you name it, has something to do with an employment decision being based upon one of these 5 classifications. That's a disparate treatment claim. And these suits are kind of complicated procedurally. The way that they move through the court system is a little bit confusing, a little bit of a head scratcher, and I'll take you through this in a nutshell, just kind of show you the different steps that one of these cases will go through. So the first thing that the plaintiff, which is the employee who was messed over by the employer, has to do in filing one of these claims is they have to present to the court what is called a prima facie case, and kind of a strange term, some Latin for you. And what that just means is that they have to put forth enough evidence that on its face, and that's what the facie means, on its face it looks like discrimination has happened. So they have to put forth enough evidence that it looks like, yeah, there may be a good explanation for this, but it sure looks bad. It looks like discrimination has happened to this poor employee. So they have to put forth enough evidence that, at least, just by glancing at it, it sure looks like something fishy was going on. So that's what they have to do, is present this prima facie case. And they have to establish a few different things here to establish that prima facie case. First thing is that the employee belongs to a protected class. So in other words, they're a member of a certain race, they have a particular religion that's at issue here, whatever the case may be. Second, that the employee applied for a certain job. If we're talking about not getting hired anyway, maybe getting fired or not getting promoted or whatever the case is. But let's assume that the employees didn't get the job. That's what we're worried about here. Well, then I have to show that the employee applied for a certain job and that the employee was fully qualified. So that's important because, you can't just go around applying for jobs that you shouldn't get because you're not qualified and then saying, oh, well, they didn't hire me, because I'm an American Indian. Well, we don't let you get away with that because, you have to be fully qualified for the job. That's part of proving the prima facie case. Third, the employee was not hired. That's usually an easy one. And fourth, that the employer kept the position open and kept looking for other candidates. And so if you apply for a job and you think you're not hired because of your race or your religion or whatever, these are the 4 things you'd have to show. You belong to a protected class, you have some kind of membership in a class there. You applied for the job, you were fully qualified, but you weren't hired, and the employer kept the position open, looking for other stuff. So actually the bar's not all that high there, and that will form your prima facie case. So that's what makes that up. And we kind of went over that already. So it looks like something fishy was going on, perhaps because you were perfectly well qualified, they didn't hire you, and you're a member of a minority group. Maybe something's going on here. Well, at that point, the burden of proof shifts to the employer. And so once the prima facie case has been established, the employer has to come up with a non-discriminatory reason for not hiring the person. So they'll just have to say, well, no, I didn't hire you because, and fill in the blank, and it has to be a reason that's non-discriminatory. So let's take a look at an example of how this might unfold. We have Laura here, who applies for a job as an accountant. Laura is a black female, originally from Botswana, who is Jewish. In other words, she's got every protected classification going for her. She's a member of all these different minority groups and all that. So we have lots of potential issues here. So Laura applies for a job as an accountant at Rudy's Landscaping. Laura is highly qualified. She has a bachelor's degree in accounting, a CPA, and a master of accountancy degree from Harvard Business School. In other words, she ought to be teaching accounting somewhere rather than just keeping their books. So she's highly, highly qualified. Well, even though she was highly qualified, Rudy did not hire her. So Laura sues Rudy under Title VII. Laura can make a prima facie case. She is a member of a protected class. She applied for the job, she was qualified for the job, she wasn't hired, and Rudy kept looking for other job candidates. Okay, so she's made her prima facie case. Well, what happens next? The burden now shifts to Rudy to present a non-discriminatory reason for not hiring Laura. Rudy tells the court he did not hire Laura because she was picking her nose throughout the entire job interview. And so that's a non-discriminatory reason. Nose pickers are not a protected classification under Title VII. And so if that, she did something during the interview that turned off the employer in a big way, okay, well, then we'll probably let them off the hook then. They've, or at least, that has rebutted the prima facie case. They have made, the case that there must be something else going on besides that they didn't want to hire this person because of who she was as a member of a protected class. And so we've gotten to the next step there. The employer has presented a non-discriminatory reason for not hiring this person. So what happens next? Now that Rudy's produced this non-discriminatory reason, the case can continue. And more commonly, in the real world, rather than nose picking, what would be going on here is that, they'd say the candidate didn't have enough experience, other candidates were better qualified, or, they could say the interview didn't go well. It usually doesn't involve nose picking, but it could, just be that they said something we didn't like, or, their job, their prior history, they quit a job after 6 months, 5 different times, or something like that. They can usually come up with something, though, as an explanation in the real world. So once the employer has come up with a legal reason for acting as it did, the burden shifts back to the plaintiff. And so that was initially the plaintiff's burden to prove the prima facie case, and it was the employer's burden to show a non-discriminatory reason. Once they do that, the ball is back in the plaintiff's court now. And now the plaintiff has to prove that the non-discriminatory reason wasn't the real reason the plaintiff wasn't hired. In other words, it was a pretext. So it was nothing more than an excuse. And so, in other words, that nose-picking thing, that wasn't it. It was really because, she was a black Jew from Botswana or whatever the case might be. And so the plaintiff, it's up to the plaintiff to prove that. All right. Well, if the plaintiff can prove that the non-discriminatory reason was, in fact, pretextual, then the plaintiff is going to win the case. And so it's all up to the plaintiff now to prove, basically, that the employer is lying when they say they weren't discriminating and came up with another reason. So let's go back to our example for a moment. And continuing our story, says, although Rudy claimed he didn't hire Laura because she was picking her nose, Laura is able to prove that Rudy later hired Ted for that position. Ted is a white Christian male who was born in Texas. So, very different background. And Ted's qualifications weren't as impressive as Laura's. And so he hadn't been to the fancy school and didn't have as many fancy degrees. And this is the kicker here, Ted was also picking his nose during the entire interview, but he was hired anyway. So if Laura can show that they, what they're saying was really a farce, that they really don't care if they hire nose pickers or not, then she can win the case because she can prove that what they were saying was, as their non-discriminatory reason, they were just making that up. They were really just lying through their teeth, that they really were being discriminatory. So that's how that case would proceed. So in this situation, Laura has shown that the reason Rudy gave for not hiring her probably was not the truth. And so the court might very well side with her in her discrimination claim. In a real world situation, a plaintiff who's not hired because of a lack of experience, for instance, that might be the non-discriminatory reason. They might be able to show that all the other employees hired for similar positions in the company didn't have any more experience than they did, for instance. And so it usually doesn't come down to nose picking, but you can imagine, if a plaintiff is rejected because, they don't have, let's say, a master's degree, but then they can show that, the company has regularly been hiring people just with bachelor's degrees for the same job. They can cast doubt upon this non-discriminatory reason. And if the court, comes to believe the plaintiff, they can maybe win their case in a situation like this. The kind of case that we just examined under Title VII is what we call a disparate treatment case. And that's when we have an individual person suffering discrimination at the hands of the employer. So in this case, it was a particular individual who didn't get hired, and that was the case that we were worried about. Well, a second type of case is what we call a disparate impact case. And that's when an entire group of people who belong to a protected class suffer some kind of discrimination at the hands of an employer. As an example, let's say that we have a company where all the female employees can prove that on average they're making much lower salaries than male employees are, and that females are giving promotions at much lower rates than male employees. And so, it's not just one individual suffering this kind of harm. It's a whole group, in this case, women. You might also have a case where, the company's not promoting people of color at the same rate that they are their white employees or something like that. And so we're worried about the entire protected classification of individuals, not just one person. And that's when we have a disparate impact case. And a disparate impact case might also be brought, if we have an employer who adopts a rule that on its face seems to have nothing to do with a protected class, but ends up having some kind of discriminatory effect on that class. And so they might, it looks like on its face they're not really trying to discriminate against people, but what they're doing is having a majorly bad impact on a protected class. It ends up having what we call a discriminatory effect. So let's look at when that might happen. In our example, we have Tyrone's Chicken. And they have a rule that all employees have to be able to lift 100 pounds in order to be employed as a chicken shipper, which is a particular position on their payroll. And that's a job where frozen chickens are loaded onto trucks. That rule seems to have nothing to do with any protected class. It applies to everyone equally. So there's nothing in there about, gender or race or religion or anything like that. But all of the chicken shippers at Tyrone's are men. Well, that's because most women can't lift 100 pounds. And in fact, chicken shippers never actually have to lift more than 35 pounds at a time while they are doing their jobs. And so this job description has been written in a way that doesn't really jive with reality here. Women who want to be chicken shippers could sue Tyrone's for disparate impact on their protected classification if they can show that this rule has nothing to do with the actual job qualifications and it has the effect or the impact of shutting women out of this job. And so this employer on its face is like, oh, okay, they're lifting heavy things. Well, the heavy things aren't as heavy as the job description seems to say. And so in effect, what they're doing is ensuring that all the people that get this job are men. And so a woman that wants to be a chicken shipper could potentially sue the company based upon the disparate impact there. So that's when we might have a rule like this that ends up having that kind of impact, even if on its face it doesn't look like it might be able to do that. Well, when we win a Title VII case, what happens? What are our remedies in order to make things right? Well, that will depend on the circumstances. If the employee was fired, the court can actually enter an injunction forcing the employer to hire them back and give them back pay for when they were out of work, the time that they should have been working but were wrongfully fired. So if you want to go back to the company you just finished having a lawsuit against, that is your option. So that is a potential remedy. In a disparate impact case, the court could issue an injunction forcing the company to do away with its discriminatory policy, so to actually change those unlawful policies. So it really just depends on the facts of the case. One place where we have discrimination come up, when some people might not be expecting it, is on the basis of gender and dealing with a company that won't want to hire a woman because she's pregnant. And there might actually be a rational basis for this, in logic, because the woman, probably gonna miss some work. When you're a new mommy, you're not gonna come back to work the next day after you give birth to your child. So you're gonna miss some work, which might be a burden on the company. Also, the company might be expecting you'll be making extra claims on the company health insurance plan, and that might make everyone's rates go up. And so they might be, logically concerned about that. But the law says you can't take that into consideration. It's illegal to discriminate against someone because she is pregnant, because that's just another form of gender discrimination. And so we have to be very sensitive. In an interview, you don't want to be asking, oh, when are you going to have kids? That might seem like a nice, lighthearted, kind of small talky thing. But we don't want to leave the impression that we're worried about our employees giving birth and all that, because that's really just another form of gender discrimination. It's like saying, well, we'd rather hire men because they don't have to give birth. And so we don't do that. That's prohibited based upon Title VII. Another aspect of gender discrimination is sexual harassment. And you've probably heard this term before and have some kind of idea of what it entails. But this comes up far too frequently in employment situations. And it can be obvious sometimes if, the employer is telling the employee, you're not going to get the promotion unless you give me some kind of sexual favor. That's the most obvious case, but that's not, doesn't encompass all of them either. More commonly, when sexual harassment comes up, it occurs because there's some kind of conduct in the workplace of a sexual nature that creates a hostile environment. And so people may be telling dirty jokes. They may be telling stories about their partying and stuff that they should not be telling. whatever the case may be. They may be using inappropriate terminology to refer to members of the opposite sex or something like that. But whatever they're doing is creating an environment that's very, very uncomfortable for people of the other gender to be there. And so that is what we call a hostile work environment. So we can have unwanted touching or actual sexual advances. Obviously that would create a hostile environment. If your boss is putting his hands on you in places where he ought not, that's pretty obvious. But there are also, dirty jokes, certain foul language, things that are flying around. Sometimes people like to hang up calendars with swimsuit models or, scantily clad women or whatever. All that stuff is a bad idea, a very bad idea, because it can lead to a hostile work environment, because you may think it's all in good fun, but not everyone may. And sometimes that can be really bothering people and you wouldn't even realize it maybe. So it's best to steer clear of all of that stuff, because that doesn't lead to a good place. If the employee is offended by this conduct, it may become sexual harassment. And again, it all depends on the circumstances. And sometimes it's, a pretty gray area. Somebody may think, oh, we're just having a good time. The other person's offended. Sometimes it's really hard to prove those cases. And sometimes they're really tough cases. But anyway, the best thing is just to avoid it altogether. Keep it clean, your language, your jokes, keep your pin-up calendars at home, that kind of thing. And certainly, of course, don't be getting into that unwanted touching stuff and all that kind of thing. If you're a hugger, just don't do it at the office. The best policy is just to discourage any kind of touchy-feely behavior among employees and have zero tolerance for the off-color language in the office. And, sometimes in a workplace, depending on the workplace, that's just part of the culture, but we need to do what we can to get rid of that, because it can really lead to lawsuits and stuff. And so dirty jokes, bad language need to stop at the door of the workplace, because that can create a hostile work environment. And, a lot of employers have gotten hauled into court thinking, that they were just laughing and joking around and having a good time, but somebody wasn't having a good time. And so rather than find that out when you're in court, it's best to just avoid it altogether. Well, cases involving religious discrimination often come up involving work schedules, because somebody's religion may demand that they don't work on a specific day of the week. If you're a Christian, you may want to go to church on Sunday. If you're Jewish, sundown on Friday evening through Saturday is the Sabbath. Maybe other holidays and things, stuff like that. Well, if a belief is genuinely held as a religious belief, the employer has an obligation to make what we call a reasonable accommodation for that employee. So what that means is, as long as it doesn't cause a great deal of hardship to the employer, they should make every effort they can to accommodate the employee's beliefs. And so, if your business is open 7 days a week, let's say it's a convenience store, and you're open on Sundays, but you have one employee who says, I really feel like I need to go serve the Lord on Sundays, and you have other employees, that could cover that shift, just don't schedule them, on that day. That's really all it is. And so as long as it doesn't cause some kind of great deal of hardship, you need to make efforts to accommodate that employee's religious beliefs, if possible. Religious organizations, though, I will say this, can base hiring decisions upon religious belief in part, despite Title VII. So, for instance, if you're running a Methodist seminary, you're trying to train Methodist preachers, it's okay for them to be requiring that being a Methodist is one of the qualifications for the job of teaching at that school, and that's kind of makes sense. And so, if you actually, you're talking about a religious organization, they can look at religion when they're doing their hiring, and so that's a big exception to Title VII. But we wouldn't want somebody to say, oh, well, the Southern Baptist Convention School of Preaching wouldn't hire me because I'm a Jew. That doesn't make much sense. Well, if you don't believe what we believe, you shouldn't be teaching there, is what they would say. So the Congress did write that exception into the rule, so there is that. Sometimes we have a situation where being a member of a protected class is really an essential qualification for the job. Sometimes we have a situation where just, the job really does require that somebody, be male or be female or whatever the case may be. And so sometimes we have situations where that comes up. For example, imagine that you're running a facility that cares for women who were battered by their husbands, who have experienced domestic violence. Some of those women might be extremely anxious in the proximity of strange men, even if the men are trying to help them, counsel them, be a nurse or whatever. And so they may be so traumatized anytime they see a male face, their heart rate starts going up, and in a situation like that, you're trying to make that a safe place for these women, a refuge for them. You don't want to upset them. In a situation like that, you might have a good argument for only hiring female nurses. And so a situation like that can be a special case. Now, just because, you're running just like a general hospital and, if you're saying, well, some male patients don't like a female nurse, well, that's different. That they can get used to that, or you can grab, a male nurse or whatever for that patient. You can't make hiring decisions based on that. But if you have a situation like this where the whole facility, its purpose of existence is just serving these battered women, you can make a case for that. And there actually have been cases I've seen where something like this would come up. So there may be these rare exceptions of where, being a member of a particular gender really does make all the difference. Here's an example where religion might actually become a real issue, a legitimate issue in hiring somebody. Let's say you have a tour company that wants to send tour groups to Mecca in Saudi Arabia. Well, you may know Saudi Arabia, the government there, only allows Muslims in Mecca. If you're not a Muslim, you cannot go to Mecca, not legally at least. And if you're not a Muslim and they catch you there, I have no idea what would happen to you, but I really don't want to find out. So in that case, the company would only be able to hire Muslim tour guides. And so in that case, your religion could actually be a legitimate job qualification. So a very rare case, but it could happen. When we have a situation like this where membership in a protected class is an honest-to-goodness job qualification, it is what we call a bona fide occupational qualification, or a BFOQ for short. In those cases, discrimination is allowed. If you run this Center for Battered Women, you could actually require that, you have to be a female if you want to be a nurse here. If you're the tour company, you actually have to be a Muslim if you're going to drive the bus, to Mecca. And so in those situations, even though we're hiring based upon a protected classification, it may be legitimate. And so in these special cases, I will say that the Supreme Court has said that they cannot imagine a case where race would be a legitimate BFOQ. So, that they're not saying it could never happen, but it's pretty hard to stretch my mind even to come up with an example where race would fit into this. But there are, men and women actually have biological differences. That's usually where this comes up, that sometimes there actually is a legitimate reason to hire a man or a woman for a particular job. So once in a while, there is an exception here where this would be allowed. Once Title VII was passed into law, hiring practices really had to adjust to a brave new world, because some things have been going on that had to change. And not only should we avoid making hiring and promotion decisions based upon these protected classifications, when we're doing the hiring process and we're interviewing candidates, we need to be careful not to even inquire about their membership in a protected class, because that can just set off all kinds of red flags that looks like discrimination. We might think we're just making small talk or something, but we need to be very careful about what we're asking, because if it touches upon the candidate's membership in one of these protected groups, it could look like we're trying to screen candidates based upon one of these prohibited categories. So some types of interview questions that should never be asked in a job interview would include, where are you to go to church? And for many of us, going to church is an important part of our lives, and we hold that in high esteem, and some people just like to chat about that. But in a job interview, that's not the place to chat about it. If the employee volunteers it, I wouldn't follow up on that and just say, oh, that's nice, and move on to something relevant to the job. But I would certainly never bring that up myself, and you shouldn't even ask any questions that would try to reveal what this person's religion is or that sort of thing. So that's something to avoid. Another example of a bad question to ask, is Rodriguez a Cuban name? that goes to national origin, and we can't discriminate based upon national origin. So even if we love Cubans and we want to hire more of them, we still shouldn't be asking about this because it shouldn't matter where their family originated. If again, if they're trying to make small talk and tell their family story about, grandpa coming from the old country or something, you can say, oh, that's nice, and then move on to something else. But we shouldn't ever try to ask them questions that would get them to reveal their national origin. It's just not relevant. It's a protected classification, and you're just asking for trouble if you ask questions about this. Simply, where were you born? That's also a pretty basic question, you would think. Where you grew up, where you were born, kind of a thing. Not terribly relevant, probably, and could be going to this national origin protected class, and so we should avoid that. Are you planning to have kids? It seems like lots of times women like to talk about, how many kids do you have and that kind of thing, especially. Don't do that because we go back to that gender and pregnancy issue. Because it could look like you're trying to figure out, oh, well, she thinks she's going to have another kid in the next year. I don't want to have to deal with that, maternity leave. And, so you're kind of going down a little slippery slope there. And so it's just best not to talk about that. Having kids, may also mean that your kids get sick and you have to take them to the doctor. The employee might miss work. Yeah, but we shouldn't care. We can't base a hiring decision upon somebody, whether they have a family or not. It goes back to that gender thing and all of that. So, again, it seems like in a fairly innocent small talk, but it can have some implications, throw up some red flags, so the best thing to avoid. So again, some questions might just seem like innocent small talk, but be careful not to ask any questions that might require the candidate to identify themselves as a member of a protected class, because you're just going somewhere you don't need to go and setting yourself up for a potential Title VII claim. And if it doesn't have anything to do with the job, don't ask about it. That's the safest way to go. So stick to the job, the requirements of the job. As long as you do that and relate it back specifically to the job requirements, then that's probably okay. In fact, there may be some questions that are perfectly legitimate that relate to real job qualifications, and it might seem like you're treading on dangerous ground here. For instance, you could ask somebody, if you're open 24/7, like a convenience store or a Walmart store or something that's open all the time, and you could ask them, are you able to work 7 days a week? Are you able to work on Sundays? And it doesn't ask about the religion specifically, but you need to know that because you're going to schedule them. If you want them to work on weekends, you're hiring somebody, you need to know, can they work on weekends? And so that's perfectly legitimate if the job requires that. Do you speak Spanish? Well, you think, well, that's getting close to that national origin thing. Hispanic, could be considered a race. Or lots of people speak Spanish that aren't Hispanic and aren't a member of a particular race or a national group. And if this is a job qualification, if you're wanting someone to work at the front desk that's bilingual, for instance, that's perfectly fine because that would make them a valuable employee. If half of your clients speak Spanish and you want them to be able to, that's perfectly fine. So again, if the job requires it, if the job doesn't require it and you're asking this question, that's a little suspicious, but if it would help somehow do the job, that's perfectly fine if they can do that. Are you legally able to work in the United States? Is a perfectly legitimate question to ask because employers have to make sure that employees are able to work in the United States legally before they can hire them. You shouldn't be hiring people who are not either U.S. citizens or have the proper work permits, some kind of work visa or whatever. And if they don't, you shouldn't be hiring them. So you are able to ask about that. And so that's kind of a sensitive topic sometimes, with the immigration as a political issue right now and all that. It seems like, it's dangerous ground. Well, legally, you can't hire them unless they're legally able to work in the United States. They have to have, a green card or something, however it works out, or just be a U.S. citizen. And so you need to be able to find out if you can hire them legally, so it's okay to ask about that. So it sounds like it's a bad idea, but it's actually, as long as you relate it to the work qualifications, some of these questions that sound kind of iffy or okay, but remember, just relate it to the job qualifications themselves. We have other anti-discrimination statutes as well besides Title VII. The Equal Pay Act was passed to make sure that men and women receive equal pay for doing the same work. And traditionally, that was not the case because back in the day, it was common for men to have higher wages than women. The thinking on that was the man is the head of the household, he's the main breadwinner. And so providing for the family was a man's responsibility, and we have to pay him enough money in order to do that. And if a woman's working outside the home, then that's just to supplement her husband's income, and so that's just extra money. And so we didn't have to pay women as much, was the thinking. Well, of course, times have changed on that, and the law seeks to eliminate the practice of paying women less for the same work that men are doing. And so that's what the Equal Pay Act was designed to do, to keep you from discriminating against women on how much they're getting paid for doing the same job. We also have the Age Discrimination in Employment Act, which seeks to stop discriminating against older workers. Some employers might not want to hire older workers for various reasons. And again, some of them might seem perfectly rational, if not mean-spirited, but at least rational. They will use the company health insurance more, raising premiums for everyone. Old people tend to get sicker more than young people. And so that seems like a rational argument. Or we might be worried about, well, we hire this person who's older, they're only going to work for a couple of years and then retire, and that's going to force us to fill that position again within a short period of time. So again, those are rational reasons that you might not want to hire an older person, but the law prohibits discrimination on age when it comes to hiring, promotion, pay, or benefits. We cannot discriminate against these older folks. So even though we have those rational reasons, we have to ignore those and not discriminate based upon a person's age. The Act prohibits discrimination against anyone age 40 or older, interestingly enough. So that's really what it's concentrating on, is older folks and not discriminating against them. It also eliminates a mandatory retirement age in most businesses. And, once upon a time, people would, kick out their employees when they hit age 60 or whatever. Well, we can't do that anymore with a few exceptions. Airline pilots comes to mind. Their reflexes and their health and all that, that's a real safety issue. And so the airlines normally have kind of a mandatory retirement age. When they get to a certain age, doesn't matter how well they're doing their job, they have to retire. And so there are exceptions to that. For the most part, though, we can't force someone into retirement because they hit a certain age. Interestingly, under this law, businesses can discriminate on the basis of age against employees younger than 40. So if a business only wants to hire employees over age 40, you could theoretically do so, because when they wrote the act, they were worried about old people being discriminated against. So anyway, kind of maybe a hole in the whole idea of age discrimination, but that's how the act is set up. Because of the Age Discrimination in Employment Act, employers shouldn't advertise a job as being intended for young employees, because that's just inviting litigation. One way that this inadvertently happens sometimes is by saying a job is intended for a recent college graduate. So, well, that sounds nice, doesn't it? We want someone right out of college, this could be their first job. Well, of course, we know people can graduate from college at any age, but most do it while they're young. So it certainly sounds like you're wanting to get someone who's 22. And so that can run you into problems potentially. So probably bad to say that, because by implication, it kind of says old people need not apply. So it's not good practice to do that. There's other ways around that. You could say, it's an entry-level job or something like that. It gets the same idea across. If you say it's an entry-level job and you want a college degree, then you're saying the same thing without that kind of imputation that we're looking for young people. So best to avoid that if you can. Also, we have the Americans with Disabilities Act, or the ADA, which prohibits discrimination based upon having a disability. And this act says that if a person is otherwise qualified for the job, an employer can't discriminate against them on the basis of having a disability, so long as the employer is able to make a reasonable accommodation for that disability. So let's take a look at an example here of how this could work. We have Ralph, who applies to work as a secretary at Acme Inc. Ralph is confined to a wheelchair, but is able to meet all of the qualifications of a secretary. However, Acme doesn't want to hire Ralph because his wheelchair doesn't fit between the furniture in its offices. If Acme, though, is able to rearrange its furniture and accommodate Ralph, it will have to do so and cannot refuse to hire him because of his disability. So rearranging the furniture, it's not a full remodel. They just have to scoot some desks around. If that's all they have to do so Ralph can get around the office, then they can't use that as an excuse not to hire him. So that would be a situation where if he's as qualified as everyone else or more qualified, they ought to hire him. They shouldn't be discriminating against him because he's in a wheelchair. If it's a little bit inconvenient to them, that's too bad. If it's just an inconvenience and not something a whole lot more. Reasonable accommodation means that the employer can get by with making some modest changes that don't amount to what we say is an undue burden, which would be some kind of significant difficulty or expense. So as long as they can accommodate Ralph, fairly economically, it's not that big of a deal, it's not an undue burden, then they would have to do that. And so if he is the most qualified person for the job, that's who they ought to hire. Well, changing our facts a little bit, let's say that Ralph, who is confined to a wheelchair, applies for a job at Bruno's Bricklaying. Ralph wants to be a hod carrier, which means he would have to carry heavy loads of bricks, tools, and supplies around construction sites very rapidly. Well, accommodating Ralph's disability would completely change the character of the job sites where Bruno's works, and in the best case scenario, Ralph would only be able to carry half as many bricks per day as a worker without a disability, costing Bruno's a great deal of money. So a very different scenario than when Ralph wanted to be a secretary. Here he's wanting to do a very physically intensive job. He has to go around these work sites that are full of uneven terrain and all kinds of hazards and things, and he's in a wheelchair, probably can't get around to all the places that a person who's not in a wheelchair could go, and he can't carry as many bricks. It would be costing them money. They'd have to hire 2 people if they hire Ralph instead of just 1. So that would end up being an undue burden in all likelihood. So in that case, Bruno's could say, you just can't meet our job requirements, and I'm really sorry, and we can't accommodate you without creating an undue burden on our business. And so, theoretically, Ralph, could sue Bruno, but Bruno would have a really good defense here, and so they probably would not succeed. So anyway, in a case like that, if you can make a few little changes, just to make it to where someone can function well, in this position, that's okay. If you have to completely change your business and lose a ton of money, that's probably an undue burden. And again, it depends on the circumstances of each particular case, where you draw the line on that. And as I said, reasonable accommodation, what's reasonable, that depends, on the facts of the case. So the ADA is administered by the EEOC, and in many ways, the law operates pretty much the same as Title VII with all the procedures and stuff. And we already looked at how a Title VII case kind of winds its way through the system. So similar idea here. When you're hiring someone, you cannot ask about his disabilities or how severe they are. So that's a bad idea. However, you can ask about their ability to perform job-related tasks. So for instance, if your job requires someone to be able to lift a certain amount of weight, to stand for long periods, or something like that, it's okay to discuss that in the job interview. Again, if it relates legitimately to the job requirements. Just make sure you stick to discussing the job requirements instead of quizzing that person about their disabilities. It can be, oh, how long have you been in that wheelchair? Oh, yeah. So we don't need to go there. Just talk about, well, this is what the job requires. Can you do that? What would you need to be able to do that? Talk about, reasonable accommodations. It'd be okay. So just relate it to the job requirements themselves, and that's probably fine. Now we're going to shift our gears a little bit and talk about affirmative action. And that's a process where some businesses have gone the extra mile, trying to remedy past discrimination, really, by having a hiring preference for members of protected classes, such as racial or ethnic minorities or women. They want to increase their diversity. They just want to make sure that they are, have a diverse workforce in terms of a gender balance, and people from different ethnic backgrounds, people of color, and people who are white, and people of different religious backgrounds or whatever, that they're wanting to have a diverse group of employees. And so that sounds like a good thing. But sometimes when they're affirmatively trying to do that, we have a little bit of controversy. So this preference is called an affirmative action policy. They're actually trying to increase the diversity of their workforce by making sure they hire people from these different backgrounds. And again, the rationale to support this policy is that it helps remedy past discrimination. So for example, A racial minority might make up 20% of the population in a given place, but because of past discrimination pre-Title VII, before the Civil Rights Movement and all that, they only account for 2% of the people in a certain profession, let's say. So, if you run a hospital, 20% of the people in the neighborhood are black, but only 2% of your nurses are black, or whatever you might be looking at. You realize that your workforce is not as diverse as it would naturally be, and that's probably because of past discrimination. Well, an affirmative action plan may be seen as a way to address that historical inequality by helping this minority group, giving a helping hand to minority job applicants to make sure that your workforce becomes as diverse as the community that it's in. Well, these plans can get to be extremely controversial because they can be used in a way that discriminates against job applicants who belong to a majority group. And so by helping the minority, we may be discriminating against the majority group. And Title VII is intended to protect members of majority groups just as much as minority groups. Title VII says nothing about it's okay to discriminate against white males. It doesn't say that at all. You're just not supposed to use race or gender or any of those other classifications at all. Not to help one group or not to hurt another group. You're just not supposed to use them at all. So, for example, white employees could sue because of racial discrimination, just like members of racial minorities. Nothing in Title VII says you have to be a member of a minority before you can suffer discrimination. So the problem is that the Title VII addresses is using those classifications in the first place. It's not how you use them. You're just not supposed to look at that stuff when you're hiring people. And so it's certainly possible to violate Title VII by discriminating against a majority group just as much as it would be to discriminate against a minority group. Critics often argue that affirmative action plans engage in reverse discrimination or discrimination against members of majority groups. And Title VII actually doesn't talk about reverse discrimination. It just discrimination is discrimination. But that term reverse discrimination means discriminating against the majority is how we use that term. And as I said, reverse discrimination is prohibited by Title VII just as much as any other kind of discrimination. And there really is no distinction at all. And because of that, severe restrictions have been placed on affirmative action policies by the courts. And we're not going to get into the weeds too much on this, but just as an example, an employer cannot use what we call quotas, where it sets out to hire a certain percentage of workers who belong to a particular group. And so it would be illegal for a company to say, well, we want 20% of our secretaries to be of color. Cannot do that. It might seem like a laudable goal that we want to increase our diversity, but we can't do that because that's using race, which is a protected classification, as a major job requirement. We can't do that. That's illegal. A lawful affirmative action plan that actually plays by the rules has to consider a job candidate's minority status as only one of many factors in the decision-making process. And what happens is if the company has ended up looking at two equally qualified workers, if it has a lawful affirmative action plan, then it can use that minority status as a tiebreaker, basically. And so if you have two applicants for the job, they both have the same level of education, the same great work history, the same everything, but one of them is a member of a minority group and you're trying to increase your diversity, then that's when you could look at their minority status. And so that's a very tricky territory to get into because, again, it invites lawsuits and all kinds of other things. And the Supreme Court has put a lot of restrictions on it. So kind of iffy stuff, but that is where that can legally come into play. So, well, there you have it. That's our whirlwind tour of employment law. I hope that some of it will be useful to you in your future careers. Certainly there's a lot of pitfalls that you can get into, but if you ever run a business that hires or fires people, this is stuff that you need to know something about. So for now, that's everything that I have. So I will look forward to talking to you again next week.